Hey guys, this is Megan from 434 Marketing, and I'm here with Patrick Bolling with Woods Rogers. And today we're going to be talking about GDPR. If you've been watching the news recently, or even if you've just logged onto your Facebook recently, you will have noticed that a lot of people are pushing data protection. And so we're going to learn a little bit about what that actually means for you and for us as marketers. So Patrick, thank you so much for being here today.
Absolutely.
First things first, what is GDPR?
GDPR stands for the General Data Protection Regulation, and it's a law that was passed by EU Parliament in 2016, and it goes into effect May 25th, 2018, so it's coming up pretty soon. And basically, it's a data protection law, and it governs processing of all data subjects, and that's persons who live inside of the EU. Mm-hmm. And processing is a broad term under GDPR. It means use, storage, retention, collection. There's probably 15 or 16 words in the definition of processing. And so basically what it means is that if you're touching data from someone from the EU, then you're going to have to comply with GDPR.
Okay.
So broadly, that's what it is, and it's there was back in 1995 there was a law passed in the EU, a directive. It's called the Data Protection Directive, and what the GDPR does is takes basically the principles that are in that law, gives it teeth, and also strengthens some of the protections for data subjects.
Okay. So obviously it affects organizations that are in the EU,
Right.
but US-based organizations or anyone else outside of Europe, how specifically does that affect them?
So GDPR doesn't really focus on location of the processor. There's a distinction between processors and controllers. Processors, maybe that's like your web host or someone that is controlling data at your direction. Controller, you're the company. You're the one saying, I want this data. I want to collect it in this way. And so wherever you are a controller, even if you're in the US, what really matters is whose data you're getting. And so if you're getting an EU data subject's data, then you're going to have to comply with GDPR generally. So your location doesn't matter. Now, there's a question of enforcement. I mean, so say you're in the US and you process data, unlawfully under GDPR, and you say, well, so what? I mean, what are they going to do to me? And it's a good question. To a large extent, what could happen is that EU regulators could cooperate with US regulators, or there could be some action taken against your company in EU if they can get jurisdiction, and that, if there's a judgment, it could be brought to the US somehow. I don't think, like with a lot of this, no one really knows how it's going to shake out after May 25th. So it'll be interesting. But if you're a US-based company and you know that you are getting EU data, or you have some operations, even small operations in the EU, or you direct sales at EU data subjects, then you need to make a determination of whether it applies to you, because it could.
Right. So what organizations should be paying attention? Doesn't matter what size organization it is. We've been reading it could be 250 plus employees, or doesn't matter what size?
Right. GDPR does have a 250 employee cutoff, but it doesn't mean that if you're under 250 employees that it doesn't apply to you. If you're processing certain kinds of data, then it's still going to apply to you. But generally you're talking about organizations with employees over 250 employees.
Gotcha. So how do we know if we're meeting the GDPR standard?
The best thing that you can do is you're at a high level, at an executive or director level, do a determination of what data you're holding, how you're getting it. You should probably do what's called a data flow map. You can determine, okay, we're collecting email addresses here. they're then going to, to this place, and these people have access to them. Because if you're ever audited, one thing that the GDPR puts in place is the requirement that you document your data processing activities. So you're going to need to be able to show, if you're processing data, what your legal basis is for it, and that you've made an assessment that it's based on one of GDPR's 6 legal bases of processing data. So basically just figuring out what data you hold and how you're getting it is the first step, and whether GDPR applies to you.
Okay, all right. So if you're not kind of following that process and putting together a data flow and all of that, what are the ramifications if an organization isn't compliant and they have traffic coming in from the EU?
Right. If you are improperly processing data under GDPR, the highest level penalty is 4% of your global gross turnover. So your global gross revenue, 4%. You can imagine that is a pretty scary number. Now, what companies will EU regulators go after? We're not sure yet. That will shake out after May 25th. Obviously, the big data companies, Google, Facebook, they're in a good position to deal with something like that. Then you get to like a mid-sized or a small company that has data processing activity, and it's a little bit more like hands up in the air. What are we going to do here if we get tagged with 4% of our gross revenue?
Right.
So.
Okay. So you mentioned legal basis consent.
Right.
What is that? What is defined as legal basis?
So there's 6 legal bases of processing under GDPR. The ones that most companies are going to use are consent, contract, and legitimate business purposes. So consent, there's a really, really high standard for consent. And so consent given through pre-ticked check-in boxes, or things of that nature, statements that if you continue using this website, then you're agreeing to our terms and conditions. Mm-hmm. Those are a little more questionable under GDPR. If you've gotten data based on consent, and that consent was not given to the level of GDPR standards, and there's a whole bunch of language in the GDPR. It's like this consent must be, affirmatively given, affirmative and freely given, unambiguous, clear, and informed, and all this sort of language that basically says that the data subject needs to know exactly what they're consenting to in order to truly have given consent. So consent is obviously it's a good one, but the standard's high. Contract, or activities taken prior to entering into a contract, is another legal basis of processing, and that's something like say someone is on your website and you have a form that they can put in their information to basically put in a request. Contact me about your products, I want to hear about them, or send me a quote or something like that, or just someone really just entering into a contract through a form, someone signing up for a subscription, or someone placing an order online or something like that. You obviously, it's legal under GDPR for you to store data given in connection with formation of a contract and with performance of a contract.
Okay.
The third one is legal basis. The third legal basis is legitimate business interest. And I think a good example of that is something like a warranty. So say you've sold a product to a customer and you have their data, and this is an EU data subject. You have their data, and their warranty is for 30 years. You need to store their data so that you can make sure that you can, if they make a warranty claim in 25 years, you're able to identify that they are the warranted party, that the warranty is valid and unexpired, and that sort of thing. So those are kind of the 3 big ones for private companies.
Okay. So from a consent perspective, is double opt-in mandatory? So if you have someone and they're filling out a form and they're part of an email list or whatever that looks like, is double opt-in something that we should be considering?
GDPR doesn't per se require double opt-in, but if you're relying on consent, then, and you have somebody twice affirmatively say, yes, I want these, I want you to process my data in this way. I want you to send me emails. I want you to, do whatever. If they've said it twice, then it's better than once.
Right.
So it's not a per se requirement, but it's good if you can
It
get
helps.
it. Yeah.
Okay. All right. So how should we be looking at our data retention policies?
So data retention policies, there's a GDPR principle for data minimization. There's several principles in GDPR. One of them is this data minimization principle. And basically what it says is that you won't hold more information than is necessary to process data legally under GDPR. So if your data retention policy should reflect that generally, that we'll only, if we have your data based on consent, we'll only retain it until you withdraw your consent. If we have your data based on a contract, for example, we'll only hold it long enough to perform a contract. If we have a legitimate business purpose for holding your data, then as soon as we don't have that purpose, then we'll delete your data or anonymize your data. GDPR doesn't apply to anonymous data. So if there is some statistics that you have and you can't link them into an individually identifiable person, then GDPR doesn't apply at all. If you have a whole bunch of data, purchase orders, whatever, from people in Madrid, and you then scrub it of all recognizable data so that it's completely anonymous, but you can still have it, you have a business use for that data. You can see, okay, May is typically a good season for us, month for us. We sell a lot of product in May, so let's push marketing in Madrid in May. Then that's legal under GDPR as long as it's anonymous data.
So a lot of our clients, they use third-party marketing tools that manage their forms or manage their email marketing. How should we be looking at third-party marketing tools from a GDPR perspective?
So I've seen a couple different tactics. I mean, consent is one. If someone's affirmatively opted in to email marketing, then you've got a good argument that that's legal processing activity under GDPR. I've also seen, and this is part of the problem with GDPR, is that we don't know how it's going to shake out after May 25th. But you can kind of survey privacy policies and kind of look at what position companies are taking with respect to email marketing, and I've seen it set forth that we have a legitimate business interest in sending you marketing emails. I would rather rely on consent. I think if you're going to be sending email marketing to EU data subjects, then you should get their affirmative consent. And in connection with that, you may want to consider looking at what consent you got in the first place. And so if it was consent given like by a pre-ticked opt-in box, then maybe your consent isn't good enough, and you may have to go through a reconsenting exercise. And you may have gotten some of those emails recently where people companies send out emails that say, hey, we're updating our privacy policies. Do you want to continue receiving emails from us? Will you lose some people? Maybe. But maybe those people weren't interested in buying your products in the first place. So you could look at it in one of two ways. But that's how you should look at it. I think consent is the way to go for email marketing purposes.
Okay. So final question. We've noticed that a lot of other organizations are kind of going a roundabout way to kind of beat GDPR and say, we're just going to block European traffic entirely from coming to our website, or we're going to give them another experience if they are coming from the EU. Is that a wise practice? Are there kind of some ramifications that could come from that?
Yeah. I've seen that too, and I think that that's one way that you can choose to comply with GDPR, by just saying if you show up on our site and we can tell you're from the EU, then you're either just going to get blocked and not be able to use our site, or you're going to be redirected to a site where we can't collect any personal data on you. And there's the issue of cookies there that needs considering, but that's one compliance method, but the flip side of that is that it may raise questions as to, if you're saying we're affirmatively not going to comply with EU data protection standards, which are really the bleeding edge of data protection, then you may have a problem with customers. You say, well, if you're not going to do that, then what are you doing with my data? And so GDPR can be viewed as a way that you can build customer trust, and you can be transparent with your customers about what you're doing with their data. Because I know we've all read privacy policies that are 20, 30 pages long, and you're like, so what is going on here? So GDPR can be viewed as an opportunity in a lot of ways to build client trust. So that's one compliance method to block it all. I don't know that it's the best, but it's going to be circumstantial based on what your needs are. Everyone's processing data differently, processing different types of data. They have different business goals, and so there's no one-size-fits-all answer to complying with GDPR. It's just gonna vary based on what you're doing.
Okay.
So.
Well, this has all been super helpful. Thank you so much for being here
Absolutely.
today, talking through GDPR with us. If you guys have any questions at all, feel free to reach out to us.